If someone you love has passed away in California and the only real asset in their estate is the house, there's a new law that could save you months of paperwork, legal fees, and stress. It's called Assembly Bill 2016, or AB 2016. And if that home is valued under $750,000, you might be able to transfer ownership without going through a full probate. But like any law, it comes with conditions, and it only applies to certain estates starting in 2025. With the caveat that I'm a real estate broker, not an attorney, and this should not be construed as legal advice, in this video I'll break down what AB 2016 does, who it helps, and what steps you need to take if you think your family or client might qualify. If we haven't met, hi, I'm Andrew DeVries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions, and with this channel, I'm here to help you avoid costly mistakes. So let's dive in. Assembly Bill 2016 passed in 2024 and effective starting April 1st, 2025, creates a simplified legal path for transferring a decedent's primary residence without going through full probate. Here's the key. It only applies if the main asset in the estate is the home and if the fair market value of that home is $750,000 or less. Historically, even modest homes, if they were titled in the decedent's name alone, would trigger a full probate proceeding. That could mean 3 to 6 months of court involvement, legal fees, and procedural delays, even when the heirs were in complete agreement. AB 2016 changes that. If the estate qualifies, heirs can petition the court for an expedited order to transfer the home without all the hearings and the red tape that usually comes with a full probate. It's faster, less expensive, and less emotionally taxing, especially for families who just want to move forward. But the law is very specific, and if you don't meet the criteria exactly, you could end up wasting time or even risking a court rejection. That's why step 1 is knowing you qualify. So who exactly can take advantage of AB 2016? To qualify for this streamlined process, the estate has to meet very specific conditions. Let me walk you through the main ones. First, the person must have passed away on or after April 1st, 2025. This law is not retroactive. If the decedent passed before that date, the traditional probate process still applies. Second, the home must have been the decedent's primary residence. That means vacation homes, rentals, or investment properties are not eligible. The court will look for evidence like mailing address, property tax exemptions, and occupancy history. Third, the property must be worth $750,000 or less. That's based on a qualified professional appraisal, not your guess, not Zillow, and not what someone offers on the open market. If the home is even slightly over that amount, you'll likely have to go through the full probate process. Additionally, no other probate proceedings can be in motion for the estate. At least 40 days must have passed since the decedent's death before filing the petition. This gives creditors time to come forward if needed. If all the boxes are checked, you and your client may be able to skip full probate and use this new, more efficient path to transfer the home. So let's say the estate actually qualifies. What actually happens? The AB 2016 process gives heirs and beneficiaries a way to petition the court for what's called a court order determining succession to real property. And that's a mouthful. But in practice, it's a faster, simpler way to legally transfer the home into the name of the rightful heir without going through the full probate. Here's what the process typically looks like. 1. File a petition in the Superior Court in the county where the property is located. This petition will include a certified copy of the death certificate, proof that the property was the decedent's primary residence, an appraisal showing the value is at or below $750,000, and documentation to your relationship to the deceased and your right to inherit under a will or state law. Next, we'll need to notify all the heirs or interested parties, and the court will require formal notice so that any potential objections can be raised before the transfer is approved. You then need to wait for court review. This can take 4 to 6 weeks, and in most cases, there is no hearing unless someone contests the petition or something in the file is unclear. If everything's in order, the court will issue an order approving the transfer. Once that's done, you'll need to record the court order with the county's recorder's office. This step officially updates the title so the property is now legally in the name of the heir or beneficiary. There's no probate referee involved, no sale required, and no long court schedule. It's still a legal process, but compared to traditional probate, it's dramatically faster, less costly, and far more private. There's no question AB 2016 may offer some real benefits. For many families, this law will make it significantly easier to transfer the home after a loved one passes away. Here are some of the key benefits. It's faster. Traditional probate in California can take 3 to 6 months. With AB 2016, many eligible transfers can happen in a matter of weeks or a few short months, depending on the court workload. It's less expensive. You avoid probate referee fees, ongoing court filings, and often reduce or eliminate the need for full legal representation. It's more private. Full probate is a public process. AB 2016 requires notice to the heirs, but avoids multiple court hearings and filings that would normally be searchable by the public. It's emotionally easier. For families who are grieving, not having to navigate a long and technical probate case can bring real peace of mind. That said, here are a few important cautions. The value cap is strict. If the home appraises even slightly above $750,000, the petition could be rejected and full probate required. Disputes can also derail the process. If heirs disagree about who should inherit or if someone challenges the validity of the will or relationship, the court may require a full probate to sort things out. It only applies to primary residence. If there are other real estate assets or significant cash investments, those may still require a full probate unless handled through a trust or other tools. That's why even with AB 2016 in place, it's critical to consult with a probate-focused real estate expert and ideally a qualified estate attorney. We can help you avoid simple mistakes that would cost the estate time and money. AB 2016 is a big step forward for California families, especially when the only asset in the estate is the family home. If the value is under $750,000 and the conditions are right, you now have a faster, more affordable way to move forward without the stress of full probate. But like any legal shortcut, it's only helpful if it's used correctly. If you're not sure whether your estate or your client's estate qualifies under AB 2016, and if you need help valuing the property, gathering documentation, or other information needed for the court filing, my team are here to help. We've guided hundreds of Bay Area families through the probate process, and we're ready to help you determine the best step, whether that's a new simplified path or a full-service probate sale with legal alignment from day one. Call us or visit probateagent.com to schedule a consultation today. We'll help you move forward with clarity, confidence, and a plan you can trust.